Ladies and gentlemen, welcome. It's a pleasure to have you here at our first event about the Metaverse in the Metaverse. Please, my name is Lars Schlichting. I am the Chief Legal Tech Officer of Kellerhals Carrard, and it will be my pleasure to explain to you what is the Metaverse. To do so, let me change my person and let me enter into the Metaverse with you. Here I am, that's me. As you can see, I am in a metaverse. That's the metaverse of a brand that you may maybe discover later. Why am I here? Because I wanted to show you what is a metaverse. Metaverse is a place where you can have experience. Here in this case, what you can see is that we can eventually go and try to drive a car, which I will not do right now. You can move inside a metaverse and you can discover what is in the metaverse. Here we have different places that we want to see what is going on. As you can see, there is also a game right now running on the metaverse. And if you conclude the game, you get a prime. You get some prizes from the brand. You have here some information that you can receive from the brand. And you go from the metaverse to the web. So what you can see now here is that I am having an experience inside a metaverse. I am playing a little bit, but while playing, I am also, I am also having an experience. Here in this metaverse, the brand decided also to create some NFTs. NFTs are art objects that you can find and look here, that you can eventually buy if you want, and that create an interaction between the brand and the user. So why I'm telling you all this? Because I want you to understand what is a metaverse. Why are we using metaverse? Metaverse is creating, I was saying, experiences. And this experience is something that was missing in the web as we were using it today. So the real competitor of metaverse, or the service that metaverse want to substitute, are not gaming. This shall not be perceived as a game. That is the social network 2.0. That is a way that brands can use to communicate with their community. So here it's just a brand of a car, but we could have the community of a sportsman. We could have the fans of an artist, which find themselves into the metaverse, and by having this experience, by playing, by discovering, by purchasing NFT, purchasing digital assets, you can wear your avatar with digital clothes that you can eventually also change with your friends or even sell on the marketplace. You are creating interaction with your community, and that is creating value. That's why we say that the metaverse is the social 2.0. And you can see it also with the action that was taken, for example, by Facebook, which exchanged its name from Facebook to Meta. Why? Well, because they have understood that probably it's better for the brands to do some marketing through the metaverse, where you will have probably less people being there if compared to Facebook, but with much more traction, with much more use, and the return that the brands can have by using the metaverse is much bigger. So I want also to share you a little bit my presentation about the metaverse. So as I told you, it's a buzzword, the metaverse. We see a lot of names of description concerning the metaverse. We see it related to crypto. We see it related to augmented reality. We see it with NFTs, which I show you to you. We know that you can use this in virtual reality. We know that you can use this with Web3. So, but all in all, let's say metaverse is an experience. Now, we are maybe with the metaverse where we were in the 90s with internet. So the experience that you're having now with the metaverse, I will say, is quite still limited. We are still in the infancy of this industry, but probably we will have a lot more to do. Think about internet. At the beginning, in the 90s, internet was what we call now the Web 1. You could read information from internet, and that was. Then internet became Web 2. You could not only read information, you could also provide information. You had write, and that's are the social networks. So through the social network, I was reading the posts which were written by my friends, for example. And now we are slowly moving to what we call the Web 3. Not only we can read, not only we can write, we can also own. We can use blockchain to create a new layer about internet and transfer ownership of digital assets. So in the metaverse, then, as I told you, is a little bit the infancy of this industry. And we will probably see it growing once that we can use it more with augmented reality or virtual reality. Nowadays, we have already some devices that allow us to use the metaverses in augmented reality. So you see in the reality some elements which are digital and indicate and posted into the reality, as you can see from the picture above, or virtual reality. So it's me going inside a fully virtual world. And for that, you see in the picture below, there is the Oculus devices that allow you to do so. Again, that is still the beginning. I think very few of you have these devices and use it. Probably we need a better devices to have really this experience grow better. And that's what is coming. There are a lot of companies, here is an example, which are working to have new kind of devices which will increase the experience inside the metaverse. Once that these devices will be available for everybody, we can think that we can really expect a boom inside the metaverse. So here I am again. I take these 5 minutes to introduce to you what is the metaverse and to have a first experience of how metaverse works. You can choose yourself to prove the sensation of living in a metaverse. You can make a trip around in our metaverse where you are right now, or you could even try the other metaverse there are inside the Nemesis metaverse. There are many of them, and I think that you can enjoy many of it. At the end of this presentation, we will do a very short quiz. You are invited to participate. The people which will participate, from the people which will participate to the quiz, we will draw a prize in free consultancy hours from our firm. So I hope that you will enjoy and that you will participate to the quiz. In order to participate to the quiz, you have to register to the platform because we need to contact you if you win the quiz. It's very easy. When you decide to participate to the quiz, the platform will automatically ask you to register. And once registered, you can participate to the quiz. And so we can draw up a winner and inform you if you are the lucky one receiving our prize. That's it. This was the presentation for my part. I will now hand over to my colleague Eliane, which will present what are the risks for intellectual properties related to the metaverse. Eliane, the metaverse is for you.
Hello, everyone. Thank you, Lars. Hi, it is my pleasure to introduce you to my colleague Virginie. My part, as mentioned, we will dive into IP questions within the metaverse. I will quickly share my my screen with you. Just bear with me. There you go. All right. So I will start off very lawyery here with two quick disclaimers. So please bear with me. For once, the information shared with you today is for mere illustration purposes. So in case you need a specific legal advice to one of your cases, please don't hesitate to reach out to me or Virginie, of course. And then a second, as the majority of today's audience is now legally trained, we will focus today on the mere basics on IP questions within the metaverse, just to not bore you with unnecessary legalese. So let's dive right in. I will start off with giving you a very quick overview over what is intellectual property, so short IP anyway. My overview starts with actually stepping outside of the metaverse real quick to show you what the IP system in the real world, as we have known it for years, looks like. So under IP rights, we understand the four classic IP rights, as you can see here, which are patents, copyrights, trademarks, and designs. So just to give you a quick feel of what these IP rights are capable of protecting. Here is a quick outline. Patents basically protect inventions, so technical solutions for technical problems. Copyright protects work of literature and art, which includes computer programs, which will prove very useful in the metaverse space. And then we have trademarks, which protect specific signs that are used in combination with goods and or services. And then we have design rights that protect shapes and forms, so basically the exterior appearance of an object. Apart from these four classical IP rights, there's other IP rights such as know-how and trade secrets. For the purpose of today's talk, we will ignore these other IP rights and focus on the classic IP rights. So as you can see, those four classic IP rights, 3 out of those 4 require registration. They're so-called register rights. So in order for you to, for example, get a patent protection, you need to register a patent in a patent registry. Copyrights are the big exception here, as copyrights do not need to be registered in order to grant you copyright protection, meaning as of the moment you create a work protectable by copyright, you get such protection. So what are those IP rights? What use are these IP rights? What are the consequences if you actually have an IP right? Such IP right grants the holder of the right an exclusive right to use it. So if I register a patent, I will be the only one who will be eligible to use such right or to authorize the use to a third party. Good. Stepping back into the IP, into the metaverse, it's pretty straightforward. What I just gave you an overview now basically applies in the metaverse as well. So in the metaverse, your IP can be protected through these IP rights that I just laid out for you. And also, just as in the real world, IP rights of third parties are to be respected, or else you risk to infringe IP rights of third parties. Obviously, there are some metaverse-specific implications, and we will try to dive into these and give you a quick feeling of them in the next 20 to 25 minutes. So today, Virginie and I will focus on the first three of those four classic IP rights. I will start off very short and quick with patents, but then dive into copyrights in more detail. And Virginie will then go and give you some detailed information with regard to trademarks. We will somewhat leave outside our talk the designs, just for the reason that we consider the other three classic IP rights to be of more interest in the metaverse space. Good. So let's dive into patents. And here, as promised, just very shortly, what is eligible for patent protection in the context of the metaverse? I asked myself that question, and the obvious first thing that comes up, and Lars has just introduced some of these to us. So I'm thinking of hardware components here. High-tech companies, just as Apple, as Lars just told us, has developed several hardware components that are used to, for example, entering the metaverse, such as VR, so virtual reality, or augmented reality glasses. There are other hardware components as well, and that are, for example, used to enhance the user experience within the metaverse, such as, for example, Meta, so formerly Facebook's engine that reproduces the appearance of a real person into an avatar only by scanning a picture of that real person. So I'm not sure if you have created your customized avatar for today's event. If you did so, you did that manually and not by scanning a picture of yours. So using the engine of Meta, you could have just automatically been able to create an avatar. So these hardware components are, very generally speaking, eligible for patent protection, as they are technical solutions to technical problems. So this is an area where patents come into play in the context of the metaverse. I will leave out the details or the cornerstones here of patent protection, and we'll jump right into one of the many questions that I sometimes get. Is software capable of patent protection? As you might know, in order to run a metaverse, so a virtual reality world, you need software. And such software in Switzerland, and this is true for Europe as well, is generally not per se capable of patent protection. And the reason is that software is usually not a technical invention, so not a technical solution to a technical problem. As always, there are exceptions. So there is, of course, it is possible that a software brings about a technical solution. For example, if it interacts with some device. So in that case, a software would also, in principle, be capable of patent protection. But in general, per se, a software is not capable of patent protection. Good. So that was it for patents, and we'll jump right into copyrights and its implications within the metaverse. So several creations in the context of a metaverse are generally eligible for copyright protection. One example, and I will go into more detail later, is the software that is needed to run a metaverse, but also, of course, creations that are made within the metaverse. So I will start off with the software here. As mentioned before, software is used to create virtual reality worlds, and software is considered to be a work of authorship, and hence it is protectable by copyright under Swiss copyright law. As mentioned before too, no registration is needed. So from the moment on you've coded a software, you get copyright protection right from the start. What is protected though with such copyright? So as you might know, a software consists of a source code and an object code. And these codes, so the source and the object code, are protected by copyright. What is not protected, however, and this is important to keep in mind, is the underlying idea or principle that you express within such code. Good. Maybe just real quick, who holds the rights, who holds the copyright in such software? I will not go into the details here, but just outline the general rule, because we will need this later on again. According to Swiss copyright law, the author of a creation holds the copyright in such creation. So in respect to a software, the programmer who created the software in general holds the copyright in such software. As always, there are exceptions. For softwares specifically, there's a rule saying that if a programmer is employed, so if he codes software within his work duties, the employer and not the employee will hold the copyrights in such a computer program. Good. I will leave out the further details and dive right into copyright and creations that are made within the metaverse. So within the metaverse, different elements can be created, such as creations that originate from outside the metaverse. Such as, for example, you have a physical work, such as a Picasso, a Picasso drawing that exists in the real world, from which a digital copy is created in the metaverse. And then you have creations that originate from inside the metaverse, such as buildings or marketplaces or even avatars. So imagine you enter a metaverse, and you make a building, or you create your avatar, as you might have just done so today. So such creations are considered graphical user interfaces, and they can qualify as so-called artistic works and are hence protected by copyright in general. So generally speaking, whatever users generate within a metaverse is in principle eligible for copyright protection. So here again, the question, who holds the rights in such copyrights? Is it the metaverse owner, or is it the person who created such creation? Here, it's a bit more interesting than it was with the software that runs a metaverse. We need to distinguish here between two different types of metaverses, the closed metaverses and the open metaverses. So as you might guess from the word, a closed metaverse, within a closed metaverse, users cannot create any additional elements. So the metaverse owner, how I call it, basically creates all the features, and then a user can enter the metaverse without actually creating his or her own elements. So here it is pretty straightforward. Ownership of the copyrights in the additional features corresponds to the ownership in the metaverse. It gets more interesting in open metaverses, which, as you might guess as well, allows users to create their own additional elements. So here, the before mentioned general rule applies, where a user is an author because he creates the user-generated content, and he is hence considered the holder of the copyright in such user-generated content. Obviously, this is up for other agreements and up for negotiations. In case of metaverses, usually at the metaverse has terms of use, so general terms and conditions, and such terms of use usually hold licenses to the benefit of the metaverse owner, allowing the metaverse owner to actually make use of your user-generated content. So here maybe a first take home for you: whenever you step into a metaverse and consider creating something, maybe first take a look at the terms and conditions and see to whom you will grant a license with the creation of such user-generated content. Good. I think my time is pretty much up, but I will first, before I leave you over to Virginie, I would like to dive into one last topic, which are NFTs. So Lars has quickly shed a light on what you can do with NFTs, that can actually make transactions with NFTs on a blockchain. So maybe just as a quick wrap, an NFT is a token. As the abbreviation says, it's a non-fungible token. So basically a software code that represents a digital creation. And it can be traded, the NFT can be traded on a blockchain. So let's say you enter a metaverse as Lars did, and then you decide to not create your own digital creations, but to purchase an NFT which represents a digital creation. From a copyright perspective, it is very interesting to look at what you actually acquire when you purchase an NFT. So put differently, what are you allowed to do when you acquire an NFT? Are you allowed to use the underlying digital creation as if you are the owner of the copyrights in it, or do you actually not have any rights within the digital creation? So in order to answer that question, it is important for you to note that, first of all, and we've looked at this before, the digital creations are protected by copyright, and the author holds such rights. So the author has an exclusive right to use such creations and to authorize third parties to do so. So he can decide who can copy, who can distribute the work he created. Further, it is important to note that the NFT does not contain the digital creation itself, but merely actually only a link to a file that contains the metadata of the digital creation, and a link that yet again redirects you to yet another file that then contains the digital creation. So we have the NFT, then we have a file with the metadata and the link, and then we have a file that contains the actual digital creation. So whenever you purchase an NFT, you don't necessarily acquire the rights in the underlying digital creation that is represented in the NFT. So this again is up for debate and up for agreement between the parties. When you purchase an NFT, you need to agree on whether or not you have any rights in the underlying digital creation or not. Usually metaverses, as mentioned before, they have terms and conditions, and usually such terms also contain licenses, not just to the benefit of the metaverse owner, but also to the benefit of a purchaser of an NFT to use and maybe also reproduce the digital creation that is represented in the NFT that he buys. So far, so good. So recent court cases have shown that unfortunately such terms and conditions are often unclear, especially as to the extent of the license granted, or sometimes they're even unclear of whether it is a license that is granted or if there's actually an assignment of rights in the underlying and digital creation. So maybe here, and I will leave you with this last take-home note. If you enter a metaverse and if you decide to purchase an NFT, maybe first take a look at the terms and conditions and see what you actually acquire when you get an NFT, so that you know what your rights are with regard to the digital creation that is represented within the NFT. Good. I would have another slide here with regard to infringements of copyrights. I know, though, that Virginie will shed some light on this topic more generally with regard to IP rights in general. So this is it from my side. It was a pleasure to speak in the Metaverse. I hope you enjoy the experience, and I will hand over to Lars or Virginie directly. Many thanks.
Thank you, Eliane. Good afternoon, everybody. I will try to also to share my screen. Okay, that's fine. Now we have the presentation. So now in this part, the second part of the IP presentation, I will address the topic of trademark. The purpose of this part of the presentation is to answer the following question. Should I take specific measure to protect my trademark in the metaverse? And if the answer to this question is yes, what are the action which I should take to protect my trademark in the metaverse? Just to start, for those who are not familiar with trademark law, I just want to remind some basic principle of trademark law. As Eliane has already explained before, when you protect your trademark, you always protect a trademark with reference to specific goods and services, meaning that when you apply to register your trademark, you must also provide a list of the goods and products which you want to be covered by this trademark. On the international level, there is an international classification, which is called the NIS classification. And according to this classification, goods and services are divided into 45 classes. So there is one class for each category of goods. For example, if you want to have a trademark for cosmetic, you will register your trademark in class 3. If you want to have a trademark for shoes, you will register your trademark in class 25. And in some cases, it's also important to provide a description, to provide more details about the goods and services that you want to be covered by your trademark. And then when your trademark is registered for a specific class of goods and services, this trademark is only protected for these specific goods and services. There is, however, one exception, which is the well-known trademark. That's the trademark which are so famous that they are protected regardless of the classes of goods and services, but they are very rare, and it's difficult to prove that your trademark is a well-known trademark. So now I'll come to the issue of the metaverse. The current trend about trademark is that a trademark which is registered for real goods does not extend to virtual goods. That means that if you have a trademark for shoes, it won't extend to virtual shoes sell and offer in the metaverse. The reason for that is that the virtual goods in the metaverse are not real goods. They are non-physical items, and they are actually mere virtual appearance of the real product. So this means that if you want to make sure that your trademark is also protected for virtual goods, you need to take further action to protect your trademark in the metaverse. There is only the exception of the well-known trademark, which are protected even though they are not specifically covering the metaverse. So now what you should do to protect your trademark in the metaverse. There are many pending cases. None of them is final. They are still subject to appeal. But based on these cases and also based on the guideline of the EUPO, the EUPO is the European Intellectual Property Office, and this office has issued some guidelines. There's a draft version which have been issued this summer and which now address the topic of the metaverse. So based on these cases and on the guideline, we can foreseen the future position on the matter, and we can therefore present some recommendation. So if you want to protect your trademark for virtual goods in the metaverse, you should register your trademark in class 9. Class 9 is the class for computer software. And in the description of the goods that you will provide in the trademark applications, it's not sufficient to just register your trademark for digital goods or downloadable virtual goods, but you must specify the content to which the virtual goods relate. So, for example, what is acceptable as a description, it's to register your trademark for virtual goods, namely digital shoes. So you have to specify that it's digital shoes or digital car, depending on what you are offering in the metaverse. And regarding NFT, it's not acceptable to register your trademark just for NFT, because NFT is seen by the EUPO as a mean of certification. It's not the digital goods in itself. So you must register your trademark in class 9, and in the description you should state that you are registering your trademark for downloadable digital goods authenticated by NFT. And this description will be acceptable for the European office. If you want to register trademark for services, this is easier, because you will register your trademark according to the usual and established classification for services. Regarding the services which are usually provided in the metaverse, in most of the cases, the relevant class will be class 35, which is the class for advertising, business management, organization, and administration office function. Another relevant class could be class 41, which apply to online gaming services. And then another class would be class 42, design and development of computer hardware and software. So depending on the services which you are providing or you intend to provide in the metaverse, that could be one or several of these classes. So as I said, most of the cases are still pending around the world regarding trademark in the metaverse, but based on this case and based on the EUPO guideline, we can already provide some recommendation to you. Our first recommendation will be to become familiar with the metaverse, to understand how it works, to understand if it's useful for you, and if it's useful for your company to be active in the metaverse, and then consider whether you should protect your trademark for the metaverse. And another recommendation is to regularly monitor the metaverse, because even if you decide not to be active in the metaverse, some third party could infringe your trademark in the metaverse. So it's important for you to be aware of such infringement and to be able to take actions if necessary. And this leads me to the last part of the presentation, which is the risk and opportunities which we see with respect to IP in the metaverse. It's of course not an exhaustive list, it's just the one which we find more relevant with respect to IP. So one of the risk is the increasing IP infringement in the metaverse. The metaverse offers a lot of opportunity, and it's a great thing. But of course, the negative side is that it also offers an increasing opportunity for third party to infringe IP, whether it is copyright or trademark. So as I've already said, it's important for company and for brand to monitor the metaverse, to be able to detect some IP infringement in the metaverse and to take action. And then even once you have identified some IP infringement, the other difficulty will be to be able to enforce IP in the metaverse. The first difficulty will be to identify the infringer. In some case, people will act through avatar, and of course, you cannot sue an avatar. So if you want to file a claim in front of a court, you need to know the identity of the infringer, and in some cases, it's may be difficult. The other difficulty will be to be able to determine the governing law and the competent authority to decide on such a dispute, because infringement take place in the metaverse, not in the real world. So the usual criteria will be difficult to apply. And finally, another difficulty would be to enforce claim for destruction. In the real world, when there is an IP infringement, for example, if somebody is selling some fake Gucci bags, the Gucci will usually claim for the destruction of the fake bags. But in the metaverse, for technical reasons, it's very difficult, if not impossible, to make sure that the virtual goods are destructed. So maybe in the future it will be necessary for the platform to have in place some self-regulating mechanisms to address this issue. And then, well, it's not really a risk, but it's some legal issue that I think you should consider. One of them, it's the need to adapt license agreement. If you are a party to a license agreement, whether you're a licensor or a licensee, you should maybe check your license agreement and see if you need to adapt the license agreement to also cover the use in the metaverse. And it's the same if you are a party to a trademark coexistence agreement. You may also need to adapt this agreement to cover the use in the metaverse. And finally, to terminate with a positive note, we think that there are opportunity with the metaverse and all this new development and technology. And one of these opportunities, the possibility to use NFT as a tool to authenticate goods. Some luxury brands are already using NFT to authenticate their goods. And in the field of IP, we think that it's a great opportunity, possibly a good tool to fight against counterfeit. So that's for the IP presentation. Thank you for your attention. It was a pleasure. And I think now it's time for Cornelia Stengel to present you the data protection issue with respect to Metaverse. Thank you.
Hi, everybody. I try to share my slides. I think you can see my slides now, no? Welcome to our presentation on privacy issues in the metaverse. I'm Cornelia, and I'm specialized in financial market law and data protection. I will introduce you very shortly on the data protection topic today, and my colleague Gaspare Loderer Also, a data protection specialist will then take over for the specific questions. While Cook, Spiegel, and Limp have been skeptical on the term metaverse, Apple, Snap, and Amazon are all reportedly investing to varying degrees in similar technology to that which Meta thinks will one day power its metaverse future. Cook is a big proponent of augmented reality, and Apple could announce a combination artificial intelligent augmented reality headset as early as 2023, while Snap released its first pair of augmented reality glasses as a limited beta last year and says that millions already engage with augmented reality via its app. Amazon has released several augmented reality applications over the years and is believed to have at least one augmented reality device in development. And here we see what happened around the same time last year. The Oculus virtual reality app was the most popular app in Apple's App Store, a signal that this headset was a popular Christmas gift. We are curious about this year's evaluation. Let's move to October of this year. Meta, as the company that built Facebook is now called, introduced its latest virtual reality headset, the Quest Pro. The new model adds a set of 5 inward-facing cameras that watch a person's face to track eye movements and facial expressions, allowing an avatar to reflect their expression, smiling, winking, raising an eyebrow in real time. The headset also has 5 exterior cameras that will in future help give avatar legs and copy a person's movement in the real world. After Meta's presentation was rumored in many places that this outcome was predictable, and it is suspected that the default off setting for these face tracking tools won't last long. Meta Police stated it's been clear for some years that animated avatars are acting as privacy loss leaders, and this data is far more granular and far more personal than an image of a face in the photograph. Okay, let's take a closer look. And where better to start than with the market leader? Here you can see extracts from the privacy policy for the Oculus. These are applicable when an Oculus account is used to access a Meta virtual reality product. The information that is collected, information about your environment, physical movements and dimensions when you use an XR device. How is information used? To market you, and with whom the information is shared. All related companies, including Meta, and globally, both internally with Meta and externally with our partners and with those you connect and share with around the world. In other words, pretty much everyone. Meta also has an additional privacy policy, which also covers these products and the associated data processing. Here, information is processed on physical characteristics and movements. Hands, eye, facial expressions have extra policies. Fitness information, so fitness level and goals. Environmental information and dimensions. We have more on the next slide. Also, camera and audio information and voice interactions are processed. And the purpose, you can see it, Meta products share information with other Meta companies to personalize offers, ads, and other sponsored or commercial content. Maybe there is a relation to the privacy concerns and the metaverse being associated mainly with Facebook or Meta. Last year, WhatsApp, which belongs to Meta, was fined a record €225 million by the Irish data protection regulator, who is notably considered to be a soft data protection agency. The fine was related to processing of information between WhatsApp and other Facebook companies. WhatsApp was ordered to bring its processing into compliance by taking specific actions. In September of this year, Meta was fined €405 million because Instagram made accounts of children aged 30 to 17 years public by default and allowing these children to make their email and phone number public. The data protection authorities in Switzerland, but also the EU, consider data protection in the metaverse to be indispensable. The Swiss Federal Data Protection Officer stated, the more people transfer their social lives to digitally animated environments, the greater the risk of their privacy being violated. This is the case, for example, with the use of photorealistic avatars, which will be perfected in just a matter of time. In this context, the Swiss Federal Data Protection Officer and other supervisory authorities will be involved at the early stage to ensure that providers of digitally animated environments clearly state the associated risks and take action to protect individuals' rights to privacy and self-determination. And these are the reasons that are regularly cited. I will not read them out now, just one key figure. Spending just 20 minutes in a virtual space simulation leaves nearly 2 million unique recordings of body language. So participation in the metaverse will involve the collection of huge amount and types of personal data. Today, smartphone apps and websites allow organizations to understand how individuals move around the web or navigate an app. Tomorrow, in the metaverse, organizations will be able to collect information about individuals' physiological responses, their movements, and potentially even brainwave patterns, thereby attain a much deeper understanding of their customers' thought processes and behaviors. Imagine a user that sees a picture of a shiny red car. In virtual reality experience, the emotional response can be analyzed and tracked, including how it changes over time. Pupil dilation could convey the excitement the user feels and see the car and skin responses to tell how intensely a person feels in a particular emotion. This type of opportunity comes with a great data protection responsibility. Businesses developing or participating in the metaverse will need to comply with data protection legislation when processing personal data in this new environment. The nature of the metaverse raises a number of issues around how that compliance will be achieved in practice. Let me hand over now to Gaspare Loderer, who will deep dive into the topic.
Thank you, Cornelia. Let me see whether I'm able to share my slides. Here we go. And thank you, Lars, for enabling such a great event in the Metaverse. The first question we have to ask ourselves is what law actually applies in the Metaverse? And as you know, in 1 year, we will get a new law in Switzerland. That's the Federal Act on Data Protection. And that will be 1st of September 2023. And all references made on my slides will be to the new law. So that's why it's a letter N before the Federal Act on Data Protection. And according to the new law, the law will apply to matters that have an effect in Switzerland, even if they are initiated abroad. And this is a very all-encompassing clause and has a very big territorial scope. So it might be sufficient if we have a user in Switzerland, then it might be sufficient for the Swiss law to apply. And then as a side note, if you want to raise private law claims or infringement of your personality rights, then you have to look at the provisions of the Private Act on International Law. And then in the European Union, we have the General Data Protection Regulation, the GDPR, which has a provision in paragraph 1 of Article 3 and states that the GDPR applies if you have a controller or a processor established in the European Union. And then probably more importantly for the Metaverse context, we also have a similar provision to the new Swiss law. If we don't have a controller or processor in the European Union, then the GDPR can still apply if persons in the EU are targeted by means of offering goods or services to them, or if we monitor their behavior. And this will also lead to the GDPR being applicable in many instances in the Metaverse context because we have also a very broad extraterritorial provision. Once we have established what law applies, we then have to ask ourselves the question whether we're actually processing personal data. And on the right side, you can see a picture of my avatar. I try to make him resemble as closely as possible to my actual appearance, even though I forgot the glasses. But to be honest, I didn't see the option, so I was very surprised when I saw Lars and his avatar have glasses. I didn't see that. But if I have an avatar like this, then probably it's close enough for people, at least people who know me, to be able to recognize me. And personal data is defined as any information relating to an identified or identifiable natural person. And then the GDPR goes on and states, slightly more detailed than the Swiss law, that it's sufficient to be able to be identified even indirectly. And you might ask yourself the questions, well, what about people who didn't create an avatar? In my case, I had to create a login as well. So I used my Apple ID to sign in into the Metaverse today. And in that case, we also have personal information. But then many of you didn't sign in with a personal avatar or with a login information. And maybe you chose a name in the Metaverse. Then we also have personal data. If you didn't choose a name, possibly you can speak in the Metaverse, then your voice can be qualified as personal data. And if none of that is the case, if you only signed up as a guest today and didn't change anything, then still we have personal data because your IP address is being tracked, and that can constitute personal data as well. And if we go one step further and think about truly decentralized metaverses, such as Decentraland or Sandbox, then we've heard from Eliane and Virginie that NFT is a big thing in the metaverse, and using an Ethereum wallet with an Ethereum address, for example, can also be enough to be qualified personal data. So we have a lot of personal data that is being collected in the metaverse, but of big importance is what Cornelia touched upon, and that is specific personal data. We have in both law the provision of special categories of personal data. They include racial or ethnic origin, genetic data, biometric data, or data concerning health. And importantly, under the GDPR, and that's a difference to the Swiss law, The processing of such data is explicitly prohibited unless you have one of the exceptions that are laid out in Article 9, paragraph 2 of the GDPR, and one of them is explicit consent. And the requirements for explicit consent are rather high. In the digital context, this could mean replying to an email or a signature or using two-factor authentication. And we've heard many examples from Cornelia. Also, we've heard that Facebook might be collecting some sort of fitness information about its user. So that could qualify as health data under the GDPR and the Swiss law. Then if people are using the voice, a lot of data can be inferred from the voice. So a lot of health data can be inferred from voice, from a voice of a person, including diseases or even the racial or ethnic origin of a person. And if that's the case, then we also have special categories of personal data. But I think most importantly in the metaverse context will be the use of virtual reality headsets. And there we have to take a closer look at the law. And that's the colorful part on this slide. Because the definition of biometric data is rather restrictive under the GDPR. And what I want to focus on is the purple highlighting, which says that such data needs to be used in order to confirm the unique identification of a natural person. And that means that not all eye data is necessarily enough to be qualified as a special category of personal data. If we just have eye tracking in order to have the same eye movement in the metaverse, then this might not be enough in order to be qualified as biometric data. But if we think about a virtual reality headset provider who will use the eyes to authenticate the user, then that might be enough in order to be or to fall under the special category of personal data. Then if we consider truly decentralized metaverses, as I mentioned, Decentraland and Sandbox are some examples. Then we have 7 rules that are commonly raised, or you can find them in the internet. And the rule I want to focus on in the context of privacy law is rule number 3, which states nobody controls the metaverse. But if nobody controls the metaverse, then we have an issue with privacy law, because privacy law assumes there is a responsible party who is processing data. And the key distinction to be made in this context is the one between controller and processor. The controller is basically the person or organization who determines the purposes and means of the processing. On the other hand, the processor is just the person, organization acting on behalf of the controller. And the distinction is important because the controller has more obligations than a processor. And then there's a third category, which gained a lot of importance due to mainly the case law of the European Court of Justice, and that's the category of joint controller. And in the metaverse context, the decision I've highlighted on the slides might be of importance. The court held that the administrator of a Facebook fan page is a joint controller with Facebook regarding the processing of visitors of the fan page. And if we think about the metaverse, we'll probably have many shops in the metaverse, and who knows, they might be qualified as controllers with the host of the metaverse platform. We saw Lars today in the Skodaverse, and I've highlighted the Skodaverse because today we are on the Nemesis metaverse. But you can also see that in the Nemesis metaverse, we have different players and different metaverses, maybe hosted by different companies. And then the question arises, what's their role under data protection law? So besides the host, Nemesis or Meta or whatever, we also have the headset provider who needs to or will have a role under data protection law. And as mentioned, different companies providing different services in the metaverse. And lastly, we also have the users, of course. And the distinction is important because, as already mentioned, it comes with obligations. And one of them is that if you use a processor, you need to make sure that you have a data processing agreement. And if you're joint controllers, then under the GDPR, you must also have an agreement. But more importantly, probably, is the controller is responsible for gathering consent. And that's also more important under the GDPR than the Swiss law. But then one aspect that's equally important is the display of privacy notices, which has to be undertaken by the controller. And how will the requirement of privacy notices look in the metaverse? Hopefully not like this. This is an example of privacy notices, assuming that we have different controller in this room in the metaverse. What I think that will happen is probably more likely that the requirement of privacy notices will move towards a just-in-time notice concept, meaning you will see the privacy notice more on the moment that it's relevant to you. That's so-called notification on event. And another concept that might be or might gain importance is the concept of layered privacy notices, meaning that you will have several layers of a privacy notice. For example, the first layer being a very simple privacy notice with just the very basic details. And then if you want to know more, you can click on the second layer, or you can maybe expand some text, and then you get more details. And if you want to know all about the privacy notice, then you'll have, as a third layer, you'll have the full privacy notice. And interestingly, the GDPR explicitly states that information to data subjects may be provided in combination with standardized icons. And the GDPR also states that it's a task of the European Commission, but so far we have not seen any binding or any official icons. But what I've included on this slide is an initiative from a Swiss company or from a Swiss initiative. It's privacyicons.ch. And if we apply this to the metaverse, then we might have something that looks more like this. So the first layer might be some very basic information with some icons and maybe some text. And also the icons or the text might only appear once you actually approach a controller who is processing data. And then we have a non-intrusive way of displaying privacy notices in the metaverse. Then if we take just a brief look about the issue of decentralization and the data protection law, then I touched upon it briefly before, but it's a foreign concept to data protection law. And for example, data protection laws have the right to be forgotten and state that there must be not a lot of collecting going on, or the data must be used limited to its purposes. And if we think about decentralized blockchains, then the issue is that we have several nodes or several computers that are connected together, and all of them basically save a copy of all data processing. And lastly, in the decentralized context, you also have the issue whether encrypted or hashed data is to be qualified as personal data. And then another hot topic that's not mainly relevant to the metaverse, but that I wanted to highlight, is the issue of transfer of data. After the European Court of Justice decided in Schrems II that the privacy shield between the European Union and the US is invalid, we have the US as a country without an adequate level of data protection. And that's the view from the European Commission, but also from the EDEP in Switzerland. And this means that you have to arrange yourself with either standard contractual clauses or other options. And if you use standard contractual clauses, you also have to do a transfer impact assessment. There's light on the horizon in regard to this topic because President Biden recently signed an executive order as a first step down for a transatlantic data privacy framework. But in this regard, we have Max Schrems, who already mentioned that he's not very happy with the executive order, and possibly will see another ruling by the European Court of Justice in a couple of years. And to sum up the issue of data protection in the privacy context, and to give you some developments, I think with the metaverse, we'll have an increased connection between the digital and the real world. And also, as Cornelia mentioned, more sensitive data will be processed. And this poses an issue because the processing of data in the digital environment might have repercussion on the real life of people, including profiling or virtual harm. And then I think one important part is also that all this processing of potentially special categories of personal data might increase the importance of Article 9 of the GDPR. And the European Court of Justice is very generous, and he considers Article 9 applicable even if we only have an indirect connection. And as we saw, avatars may reflect some of that data, some of that biometric data or health data of a real person. And this is especially of relevance in the European context, because we need to have a justification for the processing of data, and the requirement of explicit consent might become even more important. And in the European Union, we have a little bit of development regarding some regulation that touches upon the metaverse and is connected to data privacy law. We have the Digital Markets Act, which is targeted at gatekeepers, so mainly services that are indispensable. For example, Google, Facebook, Amazon, and so on are to be targeted with Digital Markets Act. And there we have two provisions, one of them being that you're not allowed to use data from third-party providers for advertising if that data has been collected on your core platform. And then a second provision is that you're not allowed to combine data across the core platforms of a gatekeeper. And this provision was specifically targeted at Facebook and the sharing that goes on between all the companies of Meta, and being Instagram, WhatsApp, and Facebook. And then also the pending legislation on the Artificial Intelligence Act might have a provision that's applicable in the metaverse. And to finish, I want to make just a couple of remarks, and most of them have been already included to some extent in my previous slides. The first one is that I think we might need to reconsider the importance of eye data, because as Cornelia mentioned, we can also infer a lot of data from the eye movement, and thus we have to ask ourselves the question whether we want to protect such data more specifically. And in relation to that, we also have to make sure that the raw data of eye processing might need to be protected more than it is today. And that's it from my part. Thank you very much for your attention. And I think now we'll hand it back to Lars.
Exactly. Thank you, Gaspare. Thank you to all my colleagues for this incredible presentation. Let me join you again in the metaverse and stand up, and please a big applause to all my colleagues. Now, even if I see now there is a slightly delay in the presentation, I told you that there is a quiz. You can find it in our room here. As you can see, we have the quiz game. I invite you to join. The one who wants, you can register, and by entering into the circle, you can start and do a little bit of trivial, and say we will pick up a lucky winner where we will give some free advisory hours from Kellerhals. It was a pleasure to have you here in our event. Thank you very much for everybody for participating. Thank you again to my colleague. Thank you to the Nemesis team to make this possible. And I hope that we will see each other soon in the metaverse for a new event. Thank you, everybody, and have a nice evening.